Good afternoon, everybody. I am Michael Zuckert of the Political Science Department, and I'm here with the great honor and pleasure to introduce to you all one of the greatest constitutional scholars of our time, and as you will see, one of the greatest critics of the Constitution as well. Sanford Levinson, sitting to my right, holds degrees in both law and political science, a PhD in political science with an emphasis in political theory, I should emphasize, for those of you who are theorists out there. Currently, he serves as the W. St. John Garwood Jr., I love the chairs' names in law schools, the W. St. John Garwood Jr. Centennial Chair in Law at the University of Texas Law School. He's also, at the same time, a professor in the Department of Government at Texas. He has written many books, including Constitutional Faith, which I think would be considered by most of us who work in this field one of the leading books in constitutional theory of our time. He's written many others. I'll just mention a few of them. Our Undemocratic Constitution, Where the Constitution Goes Wrong and How We the People Can Correct It, a book that obviously relates a bit to his topic of his talk today. He has also written, more recently, a book called An Argument Open to All, Reading the Federalists in the 21st Century, a book on which I had the pleasure to serve as a commentator at a panel in honor of the publication of that book. And then just out this week, a book with his wife Cynthia Levinson called Fault Lines in the Constitution, the Framers, Their Fights, and the Flaws That Affect Us Today. Mr. Levinson, thank you.
First of all, I'm absolutely delighted to be here. And let me say, because I think it's not irrelevant to the moment we live in, that I'm especially grateful to have been invited here by Michael and Catherine Zuckert. Until today, I would have pronounced it Zuckert, because I think it's fair to say that we're interested in many of the same things and that we disagree about many of the things that we're interested in, but that we have a genuine friendship over time. And these days, I think that's worthy of mention. And I was truly pleased to get the invitation for that reason. As well, I could say the same thing, incidentally, about my old friend Sat Barber, whose seminar I'll be visiting this afternoon. But an alternative to what I will be talking about would have been how one conducts constitutional argument in a time of intense polarization and anger. But that's not my topic today, but I am extremely grateful to be here. I want to go, before I go into the body of the talk, I do want to review very briefly the sequence of books that Michael mentioned. The first, Constitutional Faith, was published in 1988, and I won't go through the whole book, but the important thing for today's purposes is that the concluding chapter was about the bicentennial of the Constitution in 1987, where everybody visiting the bicentennial exhibit, which was designed by a close friend of mine, was given the opportunity to sign the Constitution. And the last chapter was about my decision whether or not to do that, because the original Constitution, among other things, did include a Bill of Rights and certainly included some abysmal compromises with slavery. But I went ahead and signed, basically because it was good enough for Frederick Douglass, it was good enough for me. And in the late 1850s and 1860, Frederick Douglass very notably embraced the Constitution, unlike William Lloyd Garrison, who described the Constitution as a covenant of death and an agreement with hell. And in 1987, at least, I was a Douglassian. The second book I wrote that's relevant to this is the one that Michael mentioned, that is Our Undemocratic Constitution. That was published in 2003, and that began with a visit to the National Constitution Center in Washington, on which I was, I think, on a Scholars Advisory Committee or something like that. And those of you who have been there knows that the exhibition ends with a very interesting, I think it's called Founders Hall or Framers Hall, where there are life-size statues of each and every delegate there. And again, you're given an opportunity to endorse the Constitution by signing it. In 2003, I didn't. And the reason, which is certainly very relevant to what I'll be talking about today, is that I came to the conclusion that the structural provisions of the Constitution were far more important than I thought they were in 1987, and that I really was more and more perturbed by the implications of the structural provisions of the Constitution. I also came to the conclusion via the response to the book, Our Undemocratic Constitution, which was published in 2006, that most people really don't care whether the Constitution is democratic or not. I think you can demonstrate beyond shadow of a doubt that the United States Constitution is the most undemocratic constitution of a major Western purported democracy in the world. But actually, the more interesting argument is that it is, by some substantial measure, the most undemocratic constitution of the 51 constitutions of the United States. That is, the U.S. Constitution plus the 50 state constitutions. But I don't think it really mattered to most people. I think that most people care about outputs more than they care about inputs. Kind of everybody knows that law is like sausage. And the test really is it tasty? And if people are relatively satisfied by the laws, then I don't think they really care what the process is. I came to the reluctant conclusion that many people probably would be satisfied with benevolent despotism if the despot really and truly were benevolent. So my next book in 2012 was called Framed, America's 51 Constitutions, The Crisis of Governance. And that began with a chapter not on signing the Constitution, but simply talking about a lot of polling data, indicating that people were extraordinarily alienated from the national government. I think it has been years since Congress has had an approval rating higher than 15 to 20%. On any given day, it's much more likely to be between about 10 and 15%. Presidents in the last decade or two, except for the remarkable spike after September 11th, have often hovered around 50% or indeed below 50%. Donald Trump has shattered all records by getting below 40% in the first 6 months of his term, but that his numbers are not that unusual overall if you look at recent presidents. Even the Supreme Court, which has usually been the most respected institution, is now below 50%. The only national institution that really has the confidence of the American people is the military. And you can view that as good news or bad news, but it is what polling data indicate. So that's how I began Framed. It was really quite comparative in focus. The comparisons included a little bit about other national constitutions, but far, far more important were the 50 state constitutions. But beyond that, the fact that most states have had considerably more than one constitution, and that would be relevant to my overall remarks. Indiana has had only 2 constitutions. Indiana is operating under its 1851 constitutions. Michigan is operating under a 1963 Constitution, Illinois under a 1972 Constitution. I'm embarrassed to say I forget when Kentucky's relatively recent Constitution was adopted. There is nothing unusual either in states holding constitutional conventions, there have been about 235 of them over the years, and in deciding basically to scrap what they view as outmoded constitutions with constitutions more fit to the time. There are a number of reasons for this. One of them I want to suggest is that almost nobody has reverence or veneration for his or her state constitution. Indeed, it's an awful truth that most people probably don't know their states have constitutions. They certainly, most of them, couldn't name a framer, except in Massachusetts, because the 1780 Massachusetts Constitution was in fact largely written by John Adams. But Massachusetts is exceptional in that regard. The most important election that will be carried on this calendar year will be in the state of New York, which, like 13 other states, has a provision in its state constitution that requires the electorate at stated intervals to vote yea or nay on having a new state constitutional convention. New York has had either 4 or 5 constitutions, depending on your meta theory of constitution identity, whether the most recent constitution really is sufficiently different from the previous constitution. As you might gather, for a variety of reasons, including the fact that New York's constitution is highly problematic, I truly hope that the New York voters vote to have a new state constitutional convention, which I think will be endorsed by Andrew Cuomo in the New York Times and other respectable opinion leaders, unlike the case with a national constitutional convention. I can tell you 2 things. First of all, I strongly endorse the idea of a new national constitutional convention, and secondly, I am almost literally in a handful of respectable people, assuming that I simply don't announce myself as unrespectable by virtue of this view, who in fact want a new constitutional convention. But as I say, the point of Framed was not so much to talk about inputs as to talk about outputs, and to suggest that people are increasingly very, very unhappy. And for me, one of the explanations of the Donald Trump phenomenon, certainly not the only one, you obviously have to talk about campaign finance, about talk radio, about the talents of demagoguery, about the Electoral College, about the craziness of the primary systems, etc. But I would not leave out, wearing my political scientist hat, I would not leave out the United States Constitution as an explanation for the Trump phenomenon beyond simply the Electoral College. That is to say, people, for very, very good reason, are getting more and more alienated from the national government. Wherever you are on the political spectrum, left, right, or center, liberal or conservative, it really doesn't matter. The odds are very high that you don't believe that the national government will respond adequately to whatever you happen to believe are the chief issues of the day. We have so many checks and balances, also called veto points, that it becomes not impossible, but you need all the planets to align, as they rarely are, in order to achieve major change. My wife and I have a chapter in our book, which I'll get to in just a moment, in which we talk about DACA, which is much in the news right now, and constitutional theory buffs largely focus on presidential power. Did Barack Obama have the power to issue the executive order establishing DACA in the first place, and does Donald Trump have the power to rescind it without notice and comment and stuff like that? These are important issues, they're interesting, but they're not what we focus on in our book and not what I focus on at this instant. The main thing you need to know is that in December of 2010, there was beyond reasonable doubt a majority of members of the House of Representatives, a majority of the Senate, and a President of the United States, all of whom were eager to pass some version of a so-called DREAM Act that would have alleviated the problem of children brought to this country either illegally or most commonly by parents who overstayed their visas. But, as you know, that act wasn't passed. And why wasn't it passed? Because the Senate operates under rules for 45 beats 55. There was a vote, I think it was December 10th, 2010, whether or not to have a vote. It takes 60 senators to allow going ahead. The vote was 45 to 55, or 55 to 45, depending on which way you want to see it. I should note that there were 5 Democrats who voted against cloture, which means there were some Republicans who voted for it, just as there were 8 Republicans in the House who voted for it. But it didn't matter. 45 beats 55. Why is that? Because of an obscure provision of the Constitution that gives each house the right to set its own rules. A very sensible provision. You wouldn't want a Constitution that in fact specified every rule of the House and the Senate. Does that plausibly allow the Senate to adopt a rule in which 45 beats 55? I think one can fairly argue that, but that's a lawyer's argument. The reality is that we operate under the filibuster, and the filibuster has, by and large, there are exceptions, by and large been a source of mischief. We also point out that in the 1920s, a Republican representative from St. Louis, supported by an underrated Republican president, that is Warren Harding, and I'm quite serious about that, supported a federal anti-lynching law that never went anywhere because of the Senate. So this is, for me, a vivid illustration of why structures matter. So Michael mentioned the book that my wife and I have just published. I assure you that she, by and large, wrote it. She's a very, very talented author for younger audiences, and the immediate target audience is teenagers. And I want to talk for a moment about the title, that is Fault Lines. It comes obviously from theories about earthquakes, that we have earthquakes in part because of tectonic plates. Usually we can live very happily, even if, like me, one goes to law school at Stanford and spends 3 years quite near, I think it's the San Andreas Fault, that is predicted to generate another big one, somewhat like the 1906 California earthquake. Those of you who read the New Yorker magazine might recall a remarkable article about now a year or two ago about the real trauma facing Western Washington and Seattle should a huge fault line in the Pacific slip and generate a tsunami that could almost literally drown Seattle. But fault lines do have that peculiar property that most of the time we can live our lives in denial, assuming that they'll never happen, or at least not while we're around. They're low probability events that can have great consequences. So what this book talks about are various fault lines, some of them not particularly low probability events. The United States Senate, which I really dislike, I share James Madison's belief that the Senate was an evil. That's how he describes it in Federalist 62. He describes it as a lesser evil. What is it lesser to? Not getting a constitution. Because compromising and submitting to the extortionate demands of Delaware was the price paid to get the Constitution. The same is true, incidentally, the various compromises with slavery. I actually have ended up pretty much agreeing with William Lloyd Garrison that it is a covenant with death and an agreement with hell. But a very, very deep issue is whether there are not occasions when prudence requires you to make pacts with the devil. So what would have been the alternative of not acquiescing to slave owners? It would have been no constitution. And I actually believe that fair-minded people can debate which would have been worse. The Constitution we got, with its two central compromises of the Senate and slavery, or the likelihood of 2 or 3 separate countries along the East Coast who almost certainly would have fulfilled the more or less Hobbesian view of the world that Madison and others had, that this was a recipe for war, because that's exactly what happened in Europe. There are no natural barriers along the East Coast that would have prevented New England, Mid-Atlantica, and Dixie from getting into war with one another, especially if meddlesome countries from Europe had coalesced with one or the other. In none of my books do I engage in founder bashing. They did the best they could. In 1787, I think that fair-minded people can debate some of the choices they made, even for 1787, but that's not what I'm primarily interested in. So I want to mention one other book that Michael also mentioned. That is An Argument Open to All, Reading the Federalist in the 21st Century. And the key to this book is the subtitle. I'm not at all interested, frankly, in what James Madison, Alexander Hamilton, and John Jay were thinking in 1787, 1788 as brilliant tactical propagandists trying to elicit the votes of wavering delegates, particularly in New York and elsewhere. This means I'm not interested in whether they were sincere in all of their arguments. I think that you can show quite easily that they were unlikely to be sincere in all of them. You can also show quite easily that some of the arguments contradicted one another. Rather, what I'm interested in is whether Publius, and I refer in this book exclusively to Publius, except when on occasion the particular figures of Madison or Hamilton are relevant with regard to other points I want to make, but they are never relevant as the authors of the papers that were written. So you come across the Federalist Papers, and much to my dismay, I have come to the conclusion that fewer and fewer people come across all but what I've taken to call the greatest hits of the Federalist Papers, because to an extent that really and truly did surprise me. I did not go into this project expecting to believe that every one of the 85 Federalist essays was in fact worth reading in the 21st century. I came out of the book believing that that is the case, and my book consists of 85 short essays of about 800 to 2,200 words apiece on each of the corresponding Federalist, and the point is entirely presentist. Do these essays speak to us today? And if so, what do they say? And so what I want to talk about today with regard, before I turn even more than I already have, to some of the specific fault lines, insofar as Constitution Day is treated by Congress as a quasi-religious holiday, and one could present yet another lecture on whether or not it's constitutional for Congress to require each and every educational institution to present a lecture on the Constitution on or around Constitution Day. But Constitution Day has been very good for me, and so here I am to talk about the Constitution. So it does have a certain sacral overtone, and appropriate to at least Senator Robert Byrd's notion that days like today would be occasions for sermons, then I'm sure that all of you are familiar that sermons often begin with references to relevant texts, which will then be expounded upon. So let me begin with two relevant texts from the Federalist. Appropriately, the very first one comes from the very first paragraph of the Federalist, in which Publius says, quote, "It seems to have been reserved to the people of this country by their conduct and example to decide the important question whether societies of men are really capable or not of establishing good government from reflection and choice, or whether they are forever destined to depend for their political constitutions on accident and force." So that is the first text for today. The second text comes from the conclusion of Federalist 14, and it is the paragraph that I find thrilling whenever I read it. I find it truly inspiring, and so I will share it with you. Is it not the glory, quote, "the glory of the people of America, that while they have paid a decent regard to the opinions of former times and other nations, they have not suffered a blind veneration for antiquity, for custom, or for names, to overrule the suggestions of their own good sense, the knowledge of their own situation, and the lessons of their own experience. Publius goes on to talk about the American Revolution, which obviously required overthrowing what many people viewed as the greatest constitution, little c, that had been achieved. And so he says, American patriots, quote, pursued a new and more noble cause. They accomplished a revolution which has no parallel in the annals of human society. They formed the design of a great confederacy which it is incumbent on their successors to improve and perpetuate, unquote. So thus endeth the reference to gospel. So the question is a deceptively simple question. Is Publius writing only for readers in 1787, which, if so, suggests that there really is no point to reading the Federalists today, unless you happen to be interested, as many people in this room are interested, in American political thought of the 18th century, and then it surely is interesting to figure out what people were thinking. But if it doesn't speak to us today, then life is short. There are way, way too many things to read. As I've discovered, almost nobody, in fact, reads Federalist 1. Federalist 14 is a little bit more popular, but I don't know that it's the greatest hit. So why bother? Or, alternatively, can you pick this up in the 21st century and say, you know, it really does speak to us today? It is like much great political theory, and I'm certainly familiar, particularly at a place as steeped in political theory and certain approaches to political theory as Notre Dame is, that there is a huge controversy between what might be called the eternal conversation posed by great political theorists. And for today's purposes, let's stipulate that Publius was a great political theorist, and a more Skinnerian or purely historicist approach to political theory that says it's all a product of specific context, specific time. It is illusionary and, in fact, delusionary to believe that anything written before last week truly applies to our own very different contexts. So the meta question here is whether you reduce the Federalist or any other political theory to the time in which it was written and the specific conversations in which it was taking part, or if you think it does speak to us today. So what might the paragraphs I read be saying? Well, one possibility is that we, the people today, can and ought to engage in reflection and choice about the degree to which we are well governed. And we ought not be blinded by the past to believe that the answer is necessarily yes. We ought to learn from the lessons of experience. We ought not suffer blind veneration. This isn't incidentally in tension with Federalist 49, but that's another matter. We ought not be blinded by names. Well, who are the names we might be blinded by? Try Madison, Hamilton, other worthies at the Philadelphia Convention. You perhaps will not be surprised to know that I have little patience for what is usually called originalism. One reason is because I think it's close to incoherent as a genuinely systematic argument, because there was just too much disagreement, and you inevitably have to pick and choose among the historical sources, and not surprisingly, the picking and choosing is on the basis of which you think gives you the better result. But let's assume for the moment that originalism makes sense as an intellectual enterprise. That still leaves you open to the question of why should we feel bound to continue and maintain the decisions made in 1787. Now, let me be very, very clear. We might have a different conversation if the question were simply, should judges feel bound by decisions made in 1787 before the Constitution is amended in lawful ways? You've already picked up the fact that I really, let's not beat around the bush, that I basically detest the U.S. Senate. I think it's indefensible that Wyoming has the same number of senators as California, or if you think that's simply a partisan comment, that Vermont, which has 2 senators I rather like, given my own politics, has the same representation in the Senate as my home state of Texas, about whose senators I have significant doubts. But Texas has 26 million people and Vermont has 650,000, and I really don't think there is any plausible theory of democracy that justifies Pat Leahy and Bernie Sanders being able to offset Ted Cruz and John Cornyn. But I also think, alas, that it would be frivolous to bring a lawsuit saying that the U.S. Senate violates the Equal Protection Clause or violates inchoate understandings of equality, even though it clearly does the latter, because I think it is a knockdown argument. What part of 2 do you not understand? I also believe, and I probably will get to this in a few moments, that we're not well served by a fixed-term presidency in which we can't vote no confidence in a president who, for justified reasons, we don't have confidence in. Indeed, we have to talk about impeachment or the never-used 25th Amendment about basically psychological capacity, both of which raise real problems. Whereas if we had a forthright no-confidence procedure, we could talk about politics rather than about abstruse theories of what counts as a high crime or misdemeanor, or what it takes to be shown to be unfit to serve as president, as required by the 25th Amendment. But again, one response to the view that Congress should just go ahead and vote no confidence is say, what part of the fixed 4-year term do you not understand? And there are other parts of the Constitution which I think that is a knockdown response. In fact, even if you like the Senate, that is the principle of equal representation, I think that it would be a better institution if each state had 3 senators rather than 2 senators. We haven't hired any new senators since 1959, when Hawaii entered the Union, and the population is almost twice as much. But even more to the point, if you look at what Congress does, the agenda before Congress, you discover that it is remarkably more capacious than was the case in 1959. And if you run a company that makes widgets, and if you discover that the demand for widgets has gone way up, you might want to hire new employees unless you have new technology that allows the same number of employees to produce many more widgets. As wonderful as new technology is, we really can't figure out yet how new technology is going to allow more reflective deliberation and choice by 100 people on the various remarkable range of issues, many of them requiring very deep expertise. And we might be better off with 150 or 200. I still wouldn't be happy about that, because it still means that Vermont would now have 4 senators instead of 2 senators. And so Vermont and Texas would be equal, but I do think, well, a defective Senate might be marginally better. So say we could talk about constitutional interpretation when judges do it, which frankly doesn't interest me that much anymore, though I can teach it, as against how should we as citizens, not judges, how should we as citizens respond to the fault lines in the Constitution? And one of the ways I think we should respond is by engaging in reflection and choice based on lessons of experience and emulating the good folk of Michigan, Illinois, Georgia, New York, just marching through the American states. Or you can look at a number of other countries around the world, particularly after World War II or after 1979, or South Africa in 1994, where serious people are trying to design constitutions fit for the country and the times they live in. And we don't do that. We spend way too much of the time simply venerating the Constitution and not really engaged in serious conversation about what the Constitution does, how it shapes our politics. Or on days like today, we spend too much time reducing the Constitution to a series of rights allocations. This actually is relatively new. There's a wonderful book that will come out at the beginning of next year by Jared Magliocha, who teaches at the University of Indiana, Indianapolis, on the Bill of Rights. And what Jared points out is that the Bill of Rights really become important only in the 20th century. And the term Bill of Rights really becomes important only after World War II. And why does it become important after World War II? Because it is useful in the ideological fight against the totalitarian dictatorships to say we're really and truly different, which we are. I don't have any problem with that argument. And what makes us different is that we're committed to a certain bundle of rights. And this is what led Harry Truman in 1946, I think it was, but repeatedly throughout his presidency to say that the most important part of the Constitution is the Bill of Rights. It is what led to the placement in the National Archives, along with the Declaration of Independence and the 1787 text of the Constitution, the placement. Actually, here's where it becomes interesting, because nobody called it the Bill of Rights until the 20th century. And Congress sent out 12 amendments, not 10 amendments. And the very first amendment dealt with the size of districts in the House of Representatives, and it was not ratified. The second amendment dealt with congressional salaries, proposed in 1789. It was declared ratified in 1992, a mere 203 years later, which is a quite remarkable episode in our constitutional history. But one thing you should know, when people say, sometimes pounding the table, the framers must really have loved freedom of speech because they made that the topic of the very first amendment, that's simply false. It's demonstrably false. All you can say is that the Third Amendment became the First Amendment because the first two amendments didn't get the votes until the original Second Amendment got the votes in 1992, when it became the 27th Amendment. So this is a modern development to deify the Bill of Rights. as if it is the essence of the Constitution, and basically to ignore all the other provisions of the Constitution as dull and boring. The fault lines that Cynthia and I talk about, or that I wrote about particularly in Framed, are rarely taught at our nation's finest law schools, and I don't know how often they're really seriously taught, even in what remains of high school civic education, which some of you could speak to from your relatively recent experiences, or in political science courses. How much time do you spend, for example, on the mechanics of bicameralism and the fact that, unlike some bicameral systems around the world, each House of Congress has a death ray veto over any act passed by the other House of Congress? How many of you spend time talking about the presidential veto, which is probably the most powerful veto of any of the major countries in the world, and turns us, as John Adams, in fact, recognized in 1780, into a tricameral system. It's simply false to describe the United States government as operating under a bicameral system, because what the veto does, and the veto, interestingly enough, is found in Article 1, it's not found in Article 2, what the veto does is to make the president an extraordinarily important legislative official. It means that it doesn't matter if certain legislation can run all of the hurdles of the House and the Senate, because one person can simply invalidate it with a stroke of a pen. And it's very difficult to override presidential vetoes. It can occasionally be done. There have been about 2,500 presidential vetoes. 95% of them have stuck, though. And obviously the threat of a veto can have very significant consequences. Those of you who have a legal background know that entire forests have been felled to talk about the so-called counter-majoritarian difficulty of judicial review. It's an interesting problem. Surely some of the books should have been written on this problem. But let me suggest that the presidential veto, as a matter of practical consequence, is a far more important counter-majoritarian difficulty with the American system of government. And it's just never discussed. And unlike the framers in 1787, who might have had good reasons to think that the presidential veto with a 2/3 override required for each house made really good sense, Publius thought it did, maybe the lessons of experience should lead us to believe that it really doesn't serve us very well in the modern world. Maybe we should debate whether there ought to be a presidential veto at all. It is demonstrably false that the President of the United States speaks for the entire nation because of the Electoral College, as we've all learned. Presidents run campaigns based on cobbling together electoral votes, not on maximizing their overall national vote. We have the awful reality of so-called battleground states because of the Electoral College, and the pandering to Michigan or Ohio or Florida, and basically the abject ignoring of both of the states in which my wife and I spend our time, that is Texas and Massachusetts. The only reason anyone knows in Massachusetts that a presidential race is going on after the primary season is over is because the Boston television market includes New Hampshire. In Texas, let me assure you, you really have basically no idea in recent years that there's a presidential race going on, because although there are recurrent hopes like Charlie Brown in the football that this year might be different for Democrats in Texas, it's not going to be. And there is no point to a Democratic candidate campaigning in Texas, or for that matter, campaigning in California. You discover that the states with the largest cities in the country are almost never visited, and thus presidential candidates almost never give cogent speeches about urban policy, because you can predict how the states with the largest cities in the country are likely to vote. Now, you would have lost the prediction last time with Pennsylvania, where Philadelphia remains in the top 10. But you certainly would have won with regard to Illinois, California, Texas, and New York. So these are some of the fault lines. A very, very serious fault line is Article 5 itself, that is the amendment clause. The U.S. Constitution is the hardest to amend constitution among national constitutions of the world. It used to be the Yugoslav Constitution, but Yugoslavia no longer exists. And it would probably be foolhardy to say that it dissolved because it was even more difficult to amend than the U.S. Constitution, but I suspect that it didn't help. But as I've already suggested, what's really interesting is not comparing the U.S. Constitution simply with a French or German or South African or some other national constitution, but comparing it with the 50 state constitutions, and you discover, save for one glitch that I'll mention in a moment, that all of the state constitutions are easier to amend than the U.S. Constitution. The glitch is that several states, including Iowa, have so-called dual legislative session requirements, so that legislature 1 proposes an amendment, there's an intervening election, and then legislature 2 has to repropose amendment, and even then it goes to the people for ratification. Only Delaware, among the 50 states, has no procedure for popular ratification. One of the important things about the U.S. Constitution, as Publius points out and defends in Federalist 63, is that after the inspiring words, "We the people," the U.S. Constitution is resolutely opposed to a scintilla of direct rule by we the people. It's all done through representatives. That is the case in the United States only in Delaware. All the other states have some procedure for direct democracy, and this includes not only crazy states like California, but also Maine and Ohio, which have a process of what I call citizen review to complement judicial review. So in both Maine and Ohio, which you don't usually view as wild and crazy states, the citizenry, if it's dissatisfied with legislation passed by the legislature and signed by the governor, can petition to have the legislature placed on the next ballot and then vote yea or nay on whether or not to accept it or reject it. This was done in the last 10 years in both Maine and Ohio. As it happens, I liked the result in Ohio. I have split feelings about the result in Maine, but I unequivocally like the fact that there was this possibility of an appeal to the electorate. Quite frankly, with regard to Obamacare, I would rather have had a national referendum in which people would have been forced to make cogent arguments for and against than have lawyers shouting at one another, making what I confess I still regard, even after the Supreme Court's decision, as essentially frivolous arguments under the Commerce Clause about the invalidity of the Affordable Care Act. But they got 5 votes from the Supreme Court, but then Chief Justice Roberts turned around and said not to worry because it's okay under the taxing power, which led to a vitriolic dissent by Justice Scalia. Quite frankly, I know of no member of the legal academy who is suffused with great respect for the opinion of the court in Sibelius, whether you like the outcome or not. And I think this is one of the things that has led to the fact, which may or may not be unfortunate, that even the Supreme Court these days can't muster majority approval from the public. Either it's because the American public at large has all incorporated legal realism 101 and views judges as mere politicians in robes, or more generously says, no, they're not really deciding simply on the basis of their policy preferences, but they are making what my friend and colleague, sometime colleague Jack Balkin and I have called decisions based on high politics rather than low politics. That is, what is your overall vision as to what you think would best serve the country? And there's nothing wrong with thinking that way. I don't disesteem members of the Supreme Court because they have a high politics. That being said, you can still ask cogent questions as to why their high political visions should necessarily prevail over what at best can be the high political visions of members of Congress and the president, or even the high political visions of the public at large. Let me mention another couple of fault lines before returning to our texts for today. Another fault line is continuity in government. Some of the fault lines we talk about are relatively high probability, and we just live with them because we don't think anything can be done about it, quite frankly, because in fact it is so difficult to amend the Constitution. Other fault lines are low probability, but potentially catastrophic in their implications. One of them is the so-called continuity in government problem. What if Flight 93 had in fact crashed into the Capitol, killing or significantly disabling, let's say, 350 members of the House, and disabling, let us say, 60 or 70 members of the Senate? Well, the Constitution, in its 1787 wisdom, and I'm quite willing to say this made perfectly good sense in 1787, says that every member of the House must be elected. No appointed representatives, thank you. Members of the House generally detest the Senate for reasons independent of their voting allocation. One of the reasons they detest members of the Senate is because they have cushy 6-year terms instead of having to run elections every 2 years, but also because a number of members of the Senate are appointed rather than elected. It's anti-democratic. There's something to that argument. You know, I think it can be responded to, but it's not a frivolous argument. But after a catastrophic attack, it could lead to out-and-out catastrophe for the country at large, because you simply could not replenish the House until you had elections. In however many districts, you have no representatives. Senators are a little bit trickier. If the senators are killed, the grim reality is that's basically all right, because under the 17th Amendment, traced back to the original Constitution, senators can be replaced by gubernatorial appointments, except in a very few states that require election. But you could have a new functioning Senate, almost literally, a couple of days later. With the House, no. But the point is that we need a continuing government. And if you don't have a mechanism for continuity in government, and we could add to this, incidentally, an attack that kills both the president and the vice president, this is a recipe for dictatorship. And it's a recipe, almost certainly, for military dictatorship. And this is a fault line within the Constitution that we ought to be talking about. Low probability, very, very high consequence. As it happens, a commission of the Brookings Institution, which is generally viewed as liberal, and the American Enterprise Institute, which is generally viewed as conservative, after September 11th said, this is a potential problem. We ought to think about it. So they had a blue ribbon Washington group of worthies, including some former senators and others, members of what used to be called the Washington establishment that probably no longer exists anymore. Lloyd Cutler was one of the people very active in this. And they talked about it, they thought about it, and they drafted a new amendment. I actually testified before the Senate talking in favor of this new amendment. John Cornyn from Texas sponsored it. And again, I've put my cards on the table. My politics don't lead me to be a particular fan of Cornyn, but I will give him tremendous credit for his sponsoring this amendment because it brought him no campaign contributions. It did not give him any more luster with his base. Rather, it responded to his instinct for good government. And he held hearings. One of the other people who testified that day was Alan Simpson, the former Republican senator from Wyoming, who testified very much in favor of it, and then castigated the Republican chair of the House Judiciary Committee, James Sensenbrenner, who simply refused to hold hearings. And why did he refuse to hold hearings? Because Sensenbrenner is a loyal little d Democrat who was simply offended by the idea that there might be any appointed members of the House. So better that we have no functioning House, or as we talk about in one of the chapters, a House where the quorum might be, let us say, there might be 99 living members of the House, so the quorum would be 50, and then it would take 26 votes from God knows where to pass binding legislation. That apparently was just fine for Sensenbrenner. And so Senator Simpson spent almost all of his time talking about the rudeness of Representative Sensenbrenner. So we're now in 2017. We've just gone through the 16th anniversary of September 11th. And let me tell you, the continuity in government problem is just as serious today as it was then. You might say it's just as low probability as it was, but it's just as stunning in its consequence. One can also incidentally raise in this context issues with the Succession in Office Act because, quite frankly, it doesn't make much sense to have the Speaker of the House and the President pro tem of the Senate succeed in times of a catastrophe. So now let me come back and finish by adverting to the initial texts. Do we in 2017 have sufficient faith in one another to believe that we, the people, in 2017 can engage in genuine reflection and choice, can talk about the lessons of experience, and propose what I think are needed changes? Sott immediately says no. He agrees with my wife. The book concludes, the book is written in one voice, but not the final chapter, because the book concludes with a debate between my wife and myself, in which she says, as is true of most of my family and friends, you've got to be kidding. You're crazy if you think that a new constitutional convention is a good idea. And not surprisingly, I present arguments why I think it would be a good idea. But let me suggest that your views on whether or not we should have or could tolerate a new constitutional convention is a good idea or not, is a canary in the coal mine with regard to the broader issue of democracy. That if we don't believe that we as a people are capable of collective reflection and choice and deliberation, then why, in fact, give any credit not only to the presidential election, where the question would be just as powerful had Hillary Clinton won, but to any election, which after all is carried out by very ordinary people who have engaged in some kind of reflection and choice as to how to represent them. So these, I think, are the questions we should be asking on Constitution Day. I mean no disrespect to the framers. I'm wearing my Constitution Day tie that includes the signatures of each and every framer. But what I want to suggest is that the framers would have been shocked and perhaps even appalled to know that there has been only one convention and only 17 amendments following the Bill of Rights, assuming you count the original Second Amendment.
I think we have a little time for Q&A. So I will recognize people if they'd like to be recognized. Over there.
So you talked about how race election electoral college is a problem. One way I thought about it was the word generous in terms of the Constitution. Generous meaning showing a readiness to change, or correlate what is expected. So would you think of yourself as a generous person that you want to look at a way to change the Constitution on?
Well, I certainly want to modify it, change it. I'm not sure, maybe we go along. Do I want to replace it? That sounds more ominous than simply tweaking it. I mean, some of what I like to do doesn't require a constitutional convention. The continuity in government issue could in fact be handled with a standalone constitutional amendment. It's simply that Congress has no interest in addressing it. The Electoral College could probably be handled by a standalone constitutional amendment. There have been 600 such amendments offered on the Electoral College alone, but for a variety of reasons, Congress is almost certainly never going to propose a constitutional amendment. And then frankly, at that point, you run up against the ratification rule requiring 3/4 of the states, and you might well have an unholy coalition of Wyoming and Ohio, both voting to keep the Electoral College because they believe they're the winners from keeping it, whereas Indiana probably doesn't benefit or get hurt very much one way or the other by the Electoral College.
Good. Any others? Let me try the deck. Robert.
Thank you, Mr. Levinson, for a very thought-provoking and excellent presentation. My question for you is, you used the phrase on a number of occasions throughout your talk, how do the Federalists, for example, speak to us today? That term, speak to us today. As I try to think about what you meant by that, I think the question is really, is it democratic enough? If I look at all your fault lines, it seems to be, is it democratic enough? But isn't one of the ways that the Federalist speaks to us is to have us question how much of an unmitigated good democracy is, or whether or not there's something in democracy that's actually self-destructive of its own end goals unless somehow checked by the very undemocratic institution?
Oh, sure. I mean, I think you can quite easily show that Publius was not a 20th century Democrat, that the term democracy was, except for a few people like James Wilson, not a complimentary term. There's a reason they call themselves Republicans, little r, Republicans. And there are very serious arguments to be had about, first of all, what we mean by democracy, and then given your definition, whether democracy is necessarily a good thing. That being said, I have written elsewhere that the most important single public political figure in the 20th century was Woodrow Wilson, more important even than Lenin, because communism really is pretty much dead. Whereas Wilson is very much alive in terms, this year is the 100th anniversary of American entry into World War I, which was a war to make the world safe for democracy, rather than to make democracy safe for the world. Every single president since Wilson, doesn't matter what the political party is, every single president since then has committed himself, and I'm sure that Hillary Clinton would have done so had she been elected, to what I've taken to calling the democracy project. We want to support democracies around the world. Condoleezza Rice has just published a book on this theme. Well, not a single president of any political party in my lifetime has offered a cogent speech on what is the particular American theory of democracy that we want to export around the world, and whether the United States, in fact, would get an A under whatever we might be trying to sell under the democracy project. But we do know that at least since Wilson, and one might very well say since Lincoln, the conclusion of the Gettysburg Address is extremely interesting because there are real differences between government by the people, of the people, and for the people. Government for the people can easily support benevolent despotism. Government of the people simply means that the person in charge or the persons in charge should come out of the people rather than be aristocrats, but that's really it. And then you get that magic phrase, government by the people. And that suggests some real agency by the people. And we ought to talk about the extent to which we have ever believed or we continue to believe in a powerful sense of agency by the collective people or the individuals who comprise the collective people, or whether we really think that the 18th century critics of democracy were right and the devotees of a particular form of Republican form of government were correct, and be honest about it.
I think we have time for one more question.
Questions about the institution you attest to the United States Senate. It's been about 100 years since we changed the way we select senators from legislatively appointed to elected directly. So what's the difference in the way the kinds of laws the Senate passed before, and what do you think politics are like today? We still have the old rules.
Well, that's a terrific question. Let me begin with a theoretical answer, which is that the 17th Amendment negates, invalidates any serious argument that the Senate has anything to do with protecting federalism. Now, we could have a different long discussion about federalism. Sott has written very interestingly about it, but it really doesn't matter whether you like states or not. The original 1787 Constitution can be viewed as implementing certain protections for the states qua states, not based on parchment barriers, as Publius often referred to them, and specifically in Federalist 48, dealing with federalism, in which there were promises that will treat states well. No, the promise was that state legislatures would get to choose the senators, and that one could plausibly believe that the senators chosen by the state legislatures would in some sense be agents of state government and would try to protect state prerogatives, would be always on the lookout for overreaching by the national government. 17th Amendment comes along and says the people will elect senators. And at that point, senators become the agents of their constituencies. Sometimes, on relatively rare occasions, their constituencies might really, really care about an overreaching national government and might want their senators to try to rein in some abstract sense, federal power and return it to the states. But by and large, for better and for worse, electorates want their senators to bring home the bacon from the federal treasury. So one of our chapters is on the relationship between the U.S. Constitution and childhood obesity. And the connection is this. The corn-growing states in the upper Midwest are significantly overrepresented in the U.S. Senate. It's also the case that agriculture is the main topic for the senators from these states. It doesn't matter whether they're Democrat or Republican. Tom Harkin and Charles Grassley are equally devoted to retaining corn subsidies for the good folk of Iowa. And we know about the ethanol issue every 4 years. This means that federal funds go into the upper Midwestern states disproportionately, generating an excess supply of corn and of corn syrup. Now, where does this supply go? Into junk food consumed by largely children of less well-off people and less well-off people more generally. There's a fascinating article, long article in yesterday's New York Times about the Nestle Corporation in Brazil and the aggressive attempts to introduce junk food as part of the everyday diet of lower-class Brazilians. And, so can I say with any great confidence that we would have different sorts of laws if appointed senators, or if you didn't have equal voting power? I think that we would undoubtedly have some different laws. It might very well be the case that there would have been less willingness to create the modern administrative state, which relies on what Justice Cardozo, rightly or wrongly, in 1935 or so, described as delegation-run riot, and which in fact is the modern American state. And the fact is, I think if you ask people abstractly, do you like the administrative state, they probably say no. If you ask, do you like this particular administrative agency and the fact that it protects against excess lead in the water of Flint, Michigan, or it prevents other sorts of things, they say, oh yeah, I really don't want this to either be unregulated or to be left to state governments to regulate in crazy quilt regulations. In my sunset years, I have come to the belief, and this is why I began by being critical of Harry Truman, not that rights provisions are unimportant, but that we spend way too much focusing on their importance and not enough time on the potential importance of these structural provisions. So that really would be worth spending more time than we do within the discipline of political science to try to figure out what the consequences of the 17th Amendment have been. former Governor Rick Perry, and for that matter, Justice Scalia, both have suggested that it would be a good idea to repeal the 17th Amendment and go back to the original form. But let me say that wouldn't come close to being sufficient. If you really want to build protection for what Chief Justice Rehnquist was fond of calling states qua states, the federal judiciary is not going to be your savior. Even legislatively appointed senators aren't going to help you that much. What would be interesting if you treated senators as ambassadors, subject to recall by state legislatures if they violated their instructions from the state legislature to vote against some cockamamie scheme that would give more power to the national government and take it away from states. Interestingly enough, nobody seems to be suggesting that, and of course that's not the decision made in 1787. And I do think it's fair to say that the people in control of the Philadelphia Convention, by and large, did not like states all that much. Most of them liked states more than the historical figures Hamilton or Madison, as of 1787, liked states. Hamilton, I think, would quite happily have abolished them as truly independent entities. Madison was bitterly disappointed that Congress wasn't given a veto power over any and all state legislation that Congress thought ran contrary to the common good. No nonsense about the state legislation being unconstitutional. Rather, the key question was whether or not it ran contrary to the public good, and he couldn't get the votes. So the Philadelphians, they say, did have some regard for states. But it is important to note that the 1787 Constitution has almost no strongly entrenched protections for state autonomy. You look at other constitutions, and states or provinces or land or whatever are given authority over education, over religion, over natural resources, over language, which is very important. There's none of that in the Constitution. So it was very clear that a lot of reliance was being placed on the good faith of Congress not to overreach. And then at the end of the day, it turns out the senators developed quite quickly a fair degree of autonomy from the people who appointed them, though not so much as after the 17th Amendment.
Everybody join me, please, in thanking Professor Levinson.